Final case for this morning's session is 25-1169, Blaine Bolin versus the Iowa Department of Health and Human Services. Appearing on behalf of the appellant is Attorney Gary Dickey, and on behalf of the appellee is Attorney Breanne Stoltze. So, Mr. Dickey, when you're ready, just take your time getting set up there. We're ready when you are.
Thank you. May it please the court, I'm Gary Dickey from Dickey, Campbell, and Sahag Law Firm in Des Moines, Iowa, appearing on behalf of Blaine Bolin, who asked this court to reverse the district court's denial of attorney fees under sections 625.28 and 29 of the Iowa Equal Access to Justice Act. There's two questions that are presented in this appeal. The first is whether Mr. Bolin is entitled to attorney fees at all under the act. And then the second question would be what the scope of the attorney fees and costs to which he is entitled. With respect to the first issue, I think the cleanest, most narrow, and most correct way to decide this issue is that the department has forfeited its claim that its role in this case was primarily adjudicative, because it did not raise that issue until its motion to reconsider. I don't think there's any reasonable dispute that it was a new issue, a new argument that was raised for the first time. Indeed, the district court said as much, and the district court nonetheless recognized the problem with the delay in raising the issue and just simply chose to ignore it, which is directly contrary to the Iowa Supreme Court's decision in the Winger construction, this court's decision in Moffitt, and all of the decisions that we cite in footnote 2 of our initial merits brief.
Counsel, the entire dispute here revolves around 625.69, correct? All but some question about expert witness fees or something.
28 and 29, correct.
Yeah, okay. So, but the dispute or the issue that you've just identified about the adjudicative facts, that's clearly 625.29, and your claim for fees arises out of the first paragraph of 625.29, where you're entitled to fees under judicial review, except for the subsections under that. So my question is, because I think you hit it right, the 1.904 is the problem. The struggle I'm having is the identification of legal issue in Iowa for purposes of 1.904. Was this a new legal issue, or has the issue always been the application of 1.904 and the court's authority under that? To rephrase another way, under how many pieces could 625.29 be broken into and identified as legal issues? So go ahead.
What you're saying is, like, isn't that primarily adjudicative issue baked in any challenge under 29? And I disagree for two reasons. First, the district court recognized in its decision on the motion to reconsider that this was a completely new issue. That's what its words were.
Whether he correctly decided that, right? Okay.
So let's look how the arguments and issues were framed to the district court before the motion to reconsider. So we said we're entitled because we're the prevailing party. Then the onus goes upon the department to resist it. How did they resist it? They said, well, there was substantial evidence to support our position, so you're not entitled to it. That was the only issue that was raised. And so this idea of primarily adjudicative doesn't come in until the motion to reconsider. And so is it part of 29? Yes, but it's an entirely separate issue as the district court raised. Now, let me give you a counterfactual. So let's suppose the shoe were on the other foot, and we raised a constitutional issue. We said, hey, look, this is a due process issue under the 14th Amendment and the Iowa Constitution, and the court says, yeah, no, it's not really a due process issue, denied, and then we file a motion to reconsider and say, oh, but it's also a First Amendment issue, and the court, should decide it on First Amendment. I don't think anybody in this room, even though we've made this writ large constitutional issue, would say, well, since the First Amendment is also part of the Bill of Rights, that we can go ahead and consider it.
But here, I mean, we have a confined statute here. You got to meet these statutory requirements. So that's really my question. I haven't found any case law that identifies what is a legal issue, what are the confines of a legal issue for purposes of 1.904. How do we define that?
I think it's defined by how the issues were presented pre-judgment. And so the legal issues presented were, are we the prevailing party? Was there substantial evidence? And that's the end of the story. This whole legal argument and legal issue with respect to primarily adjudicative doesn't come into the picture until after the court's already made its decision. And so, if this court, I'm trying to think of a scenario in which this court could excuse that forfeiture and not open the door to all kinds of real problems in terms of error preservation, in terms of serial litigation, particularly in statutory arguments, or really any kind of legal claim that includes multiple elements or defenses. And I just don't understand how you could rule that way and not open up Pandora's box. So if this is remanded, do they get to then say, well, there's other aspects of 29 that we want to file a second motion to reconsider, or we want to ask the court to correct its decision, and so we're just in a needless litigation of these motions. So I think they've forfeited it. I think the law is clear. As I understand their argument, they are suggesting the district court had some type of inherent authority to correct a mistake. Again, this wasn't a mistake the district court made. This was an issue that was never raised. So they are entirely correct. Had they raised the issue and the district court simply reconsidered and said, in light of case law I didn't consider, I'm going to change my opinion, they would be on solid ground. But this is forfeiture, not correcting a mistake. So even if the error is preserved, they're just simply wrong, and the district court was wrong on the primarily adjudicative issue in itself.
My question, if you get past the 1.904, this is a pretty novel issue. There's not a lot of case law on it. I take it you disagree that it was primarily adjudicative. So what facts do you think take it out of that definition? Or what role of the state?
So the role of the state in a child abuse investigation is set out in the Reynolds decision. It's also set out in the Grant decision. So they've got all of these responsibilities, the primary purpose of which is protecting the child, the secondary purpose of which is collecting data to go into the child abuse registry. None of the purposes identified in either Reynolds or Grant is any type of enforcement action against the alleged abuser. Indeed, this is not an enforcement action. He's bringing an action to correct data that was put into the child abuse registry, which in his individual circumstance has some collateral consequences. But unlike the DNR actions or unlike recoupment actions where we're actually making a determination and bringing enforcement action, the state did not bring an action in this case. It went ahead and put the information in the registry and said, if you want, you can bring an action to collect the data. Again, that is more like the Ombudsman's versus Rolfe case, in which this is an investigation that, at the end, which allows a contested case, which is what we don't contest. We don't argue that is not adjudicative. A contested case is adjudicative, but that only comes at the very tail end, and only if the founded determination is wrong, and only if the individual seeks to appeal it. And so until you get to the very end, it is all entirely within the Ombudsman's case and purely investigatory. And even though it's adjudicatory in some sense, I don't think anybody can argue that it's primarily adjudicative.
A little bit further, I also found interesting the differentiation between the agency action and the court proceeding, and how do you get around that as far as asking for attorney fees for both?
Sure. So all of the tools of statutory construction support our argument, so let's just start with the text. Let's start with 29, which says, when does the court have the authority to issue these attorney fees? Well, it's actually fees and expenses or fees and other costs. It doesn't even say attorney fees. When is when there's an agency appeal or when there's a civil case that is brought by the state. So that initial threshold is only to determine the types of cases for which fees and expenses are available. So can't get fees and expenses through a PCR, can't get fees and expenses in which it's a civil case that I bring against the state in some other context. So that is the initial threshold. Does the court have the authority, because this is the type of case in which fees and expenses can be awarded. Now, what type of fees and expenses can be awarded is answered in Section 28. And there is no limitation, it's just reasonable. And so how do we know that? Because that is how the Iowa Supreme Court has interpreted the mechanics lien attorney fee section in 573. and that was the Schaffer versus Frank Moyer case. And so under 573, a successful plaintiff is entitled to reasonable attorney fees. The Iowa Supreme Court has said, well, there is no limitation. We're going to let you have appellate fees in that situation. And so in this case, we're entitled to appellate fees, but there's nothing in 28 that limits our ability to go down and take a look at the agency of fees that were incurred. Indeed, it also allows not just attorney fees, but allows for expert expenses. And when you're sitting in judicial review under 17A as a district court, we're not opening up the record for additional evidence. So it would be absurd to not look at what was incurred at the district or the agency level. Thank you.
Counsel, when you're ready.
May it please the court, counsel, Breanne Stoltze on behalf of the Iowa Department of Health and Human Services. I want to start by just touching briefly on kind of the general purpose of Section 625.29, but then want to jump to further discussion of Judge Mullen's line of questioning, because I think that answer from the Supreme Court is a little clearer than previously indicated. So to start, when the Iowa legislature enacted Section 625.29, it departed from broader federal precedent and enacted a very limited exception to the general rule that parties pay their own attorney's fees. As such, it created a roadmap with multiple limitations on district court authority to award those fees. That includes eligibility requirements, limits in the type of actions, and 8 enumerated subject matter exceptions, one of which applies here, and these mandatory bars cannot be waived under the terms of the statute. Now, to get to the question of whether something's a legal argument or a requirement within the statute, I think there's some indication of that in the Supreme Court's decision in Sandoval, which was actually discussed in the brief from my friend on the other side. There, that was a discussion of multiple petitions for post-conviction relief, and the court noted that in one case, forfeiture had not occurred because when an argument goes to the inherent illegality of a court action, whether that be through statute or the Constitution, the claim may be brought at any time. There, it was even brought on appeal. And further, we still have the court's inherent authority to consider this issue. That's the discussion in the Iowa Electric Light and Power case.
Assuming that a 1.904 motion had not been brought, I think what you're saying is the court would have had the inherent authority to go back and change its mind.
Correct, and in fact, probably had both. Oh, go ahead.
Is that really true? I mean, because the decision would have been dispositive of the case. The case is over. It's not like it's still a pending case, a pending motion for summary judgment in a case, for example, or those sorts of things. Where's the authority for the court to come back in a few days later and say, "Oops, I made a mistake. I'd like to correct that"?
Yes, as I was just about to state, that's Iowa Electric Light and Power. There you have a case where the Supreme Court said the district court had the authority to reconsider an issue despite a complete lack of a procedurally proper reconsideration motion under the rules.
Was that an issue that was dispositive of all issues in the case? Or was that a ruling in a case that still had other pending matters?
I do not know off the top of my head, but to the extent it wasn't, I would also point the court to the comments to Rule Point 1.904, where that expressly states that the rule that creates the motion to reconsider does not change a court's inherent authority to reconsider any decision as long as it still has jurisdiction over the issues and the parties. That's yeah. Yes.
Would the court have had jurisdiction here if the 1.904 hadn't been filed? Because didn't the ruling take care of all the remaining issues?
As long as the court, whereas here, still had jurisdiction over the case and the parties' judgment hadn't become final for whatever reason, yes, the district court did still have that authority. And that perhaps goes to kind of the language of the statute itself, where the court had an independent obligation to consider the mandatory bars absent any action or agreement by the parties. In fact, that's further supported by the Supreme Court's decision in Rance v. Vilsack. There you have a case where the Supreme Court stated, the parties agreed on a particular legal issue. There it was, if the line item veto at issue was invalid, then they agreed that the law took effect. The legislature or the Supreme Court had said that the parties can't kind of agree to something that leads to potentially inherent illegality and then independently evaluated the issues. Kind of goes to the notion that the parties can't stipulate to something that goes against the express terms of the statute.
To Mr. Dickey's argument that by allowing that new legal issue to come in, we're opening the floodgates to 1.904 to afford parties to litigate issues that were never raised or decided by the district court.
First, I question how a party can be kind of sandbagged by the express terms of a statute that's been in place for 40 years, but also given the statute here that provides a very clear roadmap to the district court. It says, all right, this is the type of action we're talking about. These are subjects or types of cases where the court cannot award fees, and then there's also some additional personhood requirements. So essentially it imposed an obligation on probably the district court, but if not the district court, one of the two parties, depending on where we find the burden lies, to look at this. This is a very specific kind of statutory situation where you're dealing with a specific statutory roadmap, something that even the Supreme Court has noted in, I think, Breanne at 297 was meant to be a limited exception, where you have kind of this unique type of statute, and you're not kind of looking at opening the floodgates. Second, most of the sandbagging arguments, if you look at the cases, deal with sandbagging on appeal. And that's kind of why we have kind of recognized the court's inherent authority to correct its own errors, why we have motions to reconsider, to kind of allow things to be decided by the district court, which is kind of better acquainted or steeped in the facts of that particular case. And now, if there aren't any questions on the forfeiture issue, I'd like to move to the specific mandatory bar here, and that's kind of the primary adjudicative issue. First, I want to note that, this is something that has, in fact, come before the U.S. Supreme Court on multiple occasions. You've got Remmer, Endress, Pfaltzgraff, Branstad, and kind of gives us kind of a guide for how we evaluate this particular exception. In particular, we look at Remmer, and that tells us a couple of things. First, we're looking kind of the primary agency function and whether it's to kind of adjudicate or determine someone's particular rights. But second, it also instructs that we look at the case at bar. This is where many of my friend on the other side's arguments fail. We don't look at generally what does the Department of Health and Human Services do, or even what it does with respect to these child abuse complaints. We look at what happened in the case at bar. Here, the department received a complaint, investigated that complaint, made an initial determination as to whether it was founded and registry placement, and then we had the rights of appeal that were exercised. So we had an evidentiary hearing, we had an ALJ involved, we had a final decision by the director. In fact, that tracks almost exactly what happened with the DNR in Branstad. There was an investigation of a fish kill, a complaint about a fish kill, an investigation, an assessment on restitution, an ALJ hearing, and then final agency determination. And that was found to be primarily adjudicative. And I'd say that same logic applies here. And I think we would have a different situation like we have in the Rolfs case, where that is just a fundamentally different function. There, the agency's only authority was referral to another entity. And while DHS does do that in some instances, this could have been referred to juvenile court, that isn't what we have here. We do have the ability to make an adjudication of an individual's rights, and that kind of goes to the kind of purpose of in the legislative findings under the statute, which is maintain the registry while preserving individual rights. There are kind of those two key points.
About a minute you have left. Can you address Mr. Dickey's argument about attorney fees for both the district court and for the agency?
Yes, I was just about to get to that. I would point there is a tool of statutory construction that actually directly undercuts my friend on the other side's arguments, and that is kind of the idea of different statutory terms need to mean different things. So if we look at subsection B, it talks about the state's role in the case. but then the rest of the statute talks about kind of in an action or in the action. Those have to mean different things, and Remmer tells us what one of them means. Remmer says that encompasses the agency part of the proceeding. We look at bar, what did the agency do? So inherently, that in an action has to mean something different from the agency. And the plain reading, frankly, does limit it to kind of the judicial elements of the proceedings. I think that's a little clearer if you look at that same language being used in subsection 6 and subsection 7, which also talk about kind of in an action for judicial review, and it's kind of plainly talking about that. I think kind of the appellate fee discussion's kind of a red herring, because then you're still within kind of the judicial part of proceedings, not the agency portion there. I'd also note that 629.28 talks about court costs. It doesn't talk about administrative or agency costs, further suggesting that we're only looking at the judicial piece of this proceeding. With that, I see my time's expired, so I would ask this court to affirm.
Mr. Dickey, rebuttal when you're ready.
May it please the court, with respect to the issue of forfeiture, so if we take a look at 625.29 subsection 1C, it also says that fees and expenses are not available if, quote, special circumstances exist which would make that award unjust. That's never been raised. Under the department's theory, if we win this appeal and remand down for consideration of appellate fees and they award appellate fees, the department then gets to file a motion to reconsider and ask the district court to raise that issue because they have the inherent authority and they should have done so in the first case. And that is that there would be no end to the litigation and they would be incentivized to do serial litigation. So we're going to raise an issue because we don't want the court to tell us what it means to be unjust with respect to attorney fees because we don't want that precedent set. And if we lose that, we'll do a motion to consider and we'll appeal. And if we lose that, we'll just bring it right back down and we'll just file another motion to reconsider. Clearly, that is what winger contracting was designed to prevent when the court said under these rules, you can't raise a whole new legal theory. And as the district court found, and I think that finding should be entitled to deference, this was a new legal issue and a new theory, and it perhaps better should have been brought before the judgment, but the court was going to address it anyway, and that cannot be squared with this court's precedent. With respect to the issue in terms of primarily adjudicative, if you look at the Rember decision and what was actually done here, and you set it side by side to the Grant decision, Grant explains what the whole process of a child abuse assessment case is about, which is to ensure the protection of the child and to collect data that goes into the registry. I'm not sure what right has been adjudicated in that report. We appealed the findings that were put into the registry, and the administrative process gives us the opportunity to correct that information, which is what we sought, to correct the information. And so, unlike the Branstad case, which was an enforcement action, this was not an enforcement action. This was an administrative action to correct the data. And with respect to the last issue in terms of comparing the language in the statute, I think that works the other way for the department. So if you look at their primarily adjudicative argument, and so primarily adjudicative requires the court to look at the case or in the case, they're saying we've got to look at what we did at the agency level. So they're looking at in the case globally to include both the district court level and the agency level. Well, what does the definition of fees and expenses say? It says you're entitled to reasonable attorney fees and reasonable expenses for expert witnesses, but not the portion of attorney fees or salary paid by a local unit, state, or federal government for the attorney's services in the case. It dovetails perfectly with Section 29. And so if in the case for the purposes of their primarily adjudicative argument includes the looking down at the agency level, so too does the definition of fees and expenses in terms of what are allowable and what are not allowable.
So I'm still hung up on the adjudicative nature. Are you saying that a determination that a person is identified in the registry as there having been a founded abuse has no detrimental effect or consequences to a person who's so named?
For a person like me, it would not. I mean, I'm not a child care worker. Nobody would know that it's in that registry.
You are a care worker and you're put on the registry, are there adverse consequences?
Only for second offense. So I think I think you get one bite at, well, I shouldn't say that. I don't know. I think it does, but it might have some regulatory and licensing implications. I know there is the aspect where you can have a founded but not placed, which is kind of one free bite at the apple.
A follow-up question then is, does that not make it a lot closer to an adjudicative decision if there is the possibility of adverse consequences?
Yes, we don't dispute that there is a portion of this agency action that was adjudicative, right? It's not primarily adjudicative. It only comes at the very tail end. And so had the agency action been, we find that you're a child abuser, and as a consequence, we're going to initiate an enforcement action to put you on there, then yeah, that would be an adjudicative. What they did is a child abuse assessment. They looked at the environment. They went through all of the factors of child abuse, and at the end, it was founded. And that data was then sent over to the child abuser registry, which then has the collateral consequences. Yeah. So for this reason, we ask that this court reverse the district court's decision and remand with instructions to consider appellate fees. Thank you.
Thank you. With that, the court will consider 25-1169 fully submitted and will issue a ruling as soon as possible. Thank you to both counsel for your excellent arguments today, and the court will be in recess until 1 p.m. today.